95% of the politicians investigated by the CBI and the Enforcement Directorate after 2014 are leaders of the opposition. There has been a 600% rise in cases filed by the agencies since 2014. And on the other hand, complaints filed after raids have come down from 93% to 29%. 14 opposition parties armed with these numbers and statistics approached the Supreme Court asking for guidelines against what they call political vendetta. The Supreme Court has dismissed the plea, saying essentially, you are not special if you're a politician. Come with an individual case and not a general guideline. The dismissal is being seen as a vindication of the stance that the CBI and Enforcement Directorate are indeed acting independently. But is that what has happened? Here is what the courts said today. They've said, among other things, that you cannot have guidelines exclusively for politicians. Political leaders are on the same standing as citizens. Political leaders do not claim a higher identity. And as citizens, we are all amenable to the same law. You cannot set aside prosecution on the basis of statistics. The Supreme Court also says they cannot lay down guidelines in abstract without factual basis, and laying down general guidelines will be dangerous. They've said that those who are aggrieved have to come to court in individual cases, and if space for opposition has shrunk, this was part of the petition, then the remedy is in the political space and not the courts. Now, while the opposition says that the court has not said no on the merits of the case, the BJP has hit back, saying that agencies have the right to investigate the corrupt.
They ultimately did not entertain it, but did not express a single opinion on the merits. They allowed the matter to be withdrawn. They recorded that it's at this stage, which means that full liberty is there for us to come again on new facets, new grounds. The building blocks were felt to be too broad by the court at this stage. The court felt that in individual cases we are here to save you, to protect you, to deal with you, but in a mega macro sense, we are not entertaining this at this stage.
विपक्ष के कुछ राजनीतिक दल भ्रष्टाचार करने से तो बाज आते नहीं। करोड़ों रुपए का भ्रष्टाचार करने के बाद जब जांच शुरू होती है तो कभी सड़कों पर उतरते हैं, कभी सदन रोकने का काम करते हैं। सभी भ्रष्टाचारी एक मंच पर आने का प्रयास करते हैं, लेकिन ये जनता में भी इनका चेहरा बेनकाब हुआ है और कोर्ट में भी असलियत जानने का मौका मिला है।
All right, so what are the implications of this order? To speak on this, Siddharth Luthra joins me now. He's senior advocate in the Supreme Court. Mr. Luthra, thank you so much for speaking with us this evening on Beyond the Headline as we try and go into the legal nuances of a very, very delicate and important subject. Now, how significant is this dismissal by the Supreme Court, considering that the opposition is constantly saying that the Enforcement Directorate and CBI is being misused to target the opposition?
So, there are political statements which people will make, and there are legal issues. On the one hand, there is a political discourse which is being talked about again and again, that ED and CBI, all the agencies, income tax, ED, CBI, are being applied against people who have a voice of dissent against the government, whether it be political parties or other individuals. So that's the one thing. On the other hand, when we are looking at questioning the use of an agency, or questioning the action of certain officers, or questioning the malefides of an investigation or an investigating agency, the question is really this: we have to make out a strong case on that. And the difficulty is this, if I may just point out to you, the difficulty is really this, that we test it in terms of law. Way back in the 1960s, and thereafter in 1992 in Bhajanlal's case, the Supreme Court has laid down that malefides in an investigation may be a basis to quash an investigation, but you really have to make out a very strong case. So I would say that the petition as it was framed uh, is something which is a generic petition, and it seems that is why it didn't find favor with the court. Having said that, the issue of malefides as a point to quash investigations or abuse of power to quash investigations was something which was diluted by the Supreme Court way back in the year 2000 in the Birla versus Lodha dispute. But thereafter, it has come back into the interpretation of law. And today, malefied investigations can be quashed, but you have to make a very strong case of abuse of authority or malefides. We must remember that in India, we have diluted our procedural safeguards partly through law, parliament, and executive, sub-delegated legislation, and partly to judicial interpretation. So the safeguards that were contained in the CRPC on independent witnesses have actually been whittled down to say we don't need independent witnesses on search and seizures. Keeping in view that consistent judicial philosophy, such a petition I would have felt would be very hard to meet with some success.
So is it that the petition in itself was poorly drafted? Or do you think this issue does not deserve a legal address? The fact that 40% of the vote, 42.5% of the vote in the Lok Sabha is being represented by these 14 parties that feel they are being targeted, is that significant?
I think there is a larger issue that is at stake, and it's not about the opposition parties. It's just that perhaps sometimes when the shoe pinches, they become vocal. The issue is only this. You have successfully, and I speak about this across party lines, it's not just one party in power, whether it be in the state or the center. You, our political masters, if I may call them that, have consistently responded to social situations, to social issues, to public outroar over specific instances, let's say corruption or otherwise, by enhancing the powers of the investigating agencies, whether it's state or center, by ensuring that there is a reverse burden and the presumption of innocence of an accused is diluted. You have brought in stringent conditions from bail, and you have expanded the reach of the criminal law to almost every form of human conduct. So there is a point that is going to come is when you arm individuals with excessive powers, which are untrammeled powers, and do away with fundamental premises of criminal law and of the Constitution of the right of liberty, which is the presumption of innocence, and you dilute the adversarial system of proceedings in India, where the prosecution has to prove its case beyond a reasonable doubt. Instead, now the accused has to show the innocence beyond reasonable doubt, as in Europe, which is the inquisitorial system. When you do all of that, that is the recipe for disaster which the citizen is facing. It is no longer about individuals in political outfits. The citizen who has a brush with the law, right or wrong, in a Companies Act offense, is facing strong provisions which don't allow him to come out for bail. Let me give you a simple example. I have a case which comes, example, I have a person who commits, let's say, a crime allegedly under the Copyright Act. Under the Copyright Act, he's entitled to get bail. The moment that Copyright Act offense generates proceeds of crime, money laundering comes in, he can't get bail. Now, this is the kind of law we created over the last 2 decades, or even 3 or 4 decades, I would say. And 3 or 4 decades. And if that's the case, and frankly, I must tell you, the court's interpretation has not been as liberty oriented as I would have liked it to be. And if the courts do not have a libertarian approach as they did in the 1980s, late 70s and 80s, then we are going to see a curtailment of citizens' rights with harsh laws and restrictive or constrictive interpretation, which is not necessarily pro-liberty, not necessarily liberty-oriented at all.
You know, but the court in this case seems to be saying, Mr. Luthra, that bring us individual cases, not a petition as a class of people, and in this case, that class of people happens to be politicians. Isn't that a fair ask?
I think what perhaps rather than pitching it as political parties and oppositions, what really needs to be stated is the citizens suffering on account of excessive police powers or excessive investigators' powers? And on that, I would have liked the court to interfere. This is a way. This is a petition which was perhaps doomed to fail because of the class of people who got it. But then the point is, who else other than the opposition parties will raise this issue? I wish they'd made it more citizen-centric than political party or opposition-centric. We would have perhaps had a different outcome.
So let's come to the point that you made, and that's an important one, about this being more citizen-centric and the rights of citizens that get hampered if they have a brush with the law. So who needs to address this in your view? Is this the legislative that will address it or the courts?
So Tamanna, let me just make it clear. I'm not talking about today itself. The PMLA Act came in 2005. Earlier legislations have come in. So my point is, over the last 3, 4, maybe even 5 decades, the state has consistently brought in harsher laws, increased penalties, and done a host of other things, restricting the rights and the presumption of innocence. So first address should be by Parliament, by the legislature. If the Parliament doesn't do it, it is the courts who we have to turn to, who will show the way forward by a liberty-oriented interpretation. I'll give you a simple example. In the Vijay Madan Lal Chaudhary, which upheld the PMLA case, PMLA law, and it provided a window. The window was that if there is no predicate offense, if there is no basic offense, then you can't invoke PMLA. You have seen an outlook by the Madras High Court, by the Calcutta High Court, by the Delhi High Court, using that basis and further having a liberty-oriented approach, and those judgments are now have been passed, which are citizen-oriented, liberty-oriented, rights-oriented. So if not the legislature, it will be for the government, it will be for the courts to act and secure citizens' liberty against harsh laws and excessive executive investigating and policing powers.
Do you think that this is the end of the story, or do you think the petitioners will have another go at this, Mr. Luthra?
I really hope they have a go at it, but they make it a more citizen-centric issue where they raise the aberrations in the law, where they raise the legislative overreach, so to speak, in violation of fundamental rights. I hope and pray that if such a petition comes, it will meet with good success, because that matters not only to individuals or political outfits, it matters to you and me and to every citizen.
Yeah. It's an important point. Thank you so much, top legal voice there, Siddharth Luthra, talking about how there should be a broader group of people who go in and actually petition to protect rights of